Vicarious liability in tort law is when one person is held responsible for the wrongful actions of another person. It often occurs in an employer-employee relationship, where the employer is liable for the actions of the employee if those actions occur within the course of employment. What sets vicarious liability apart is that the person held liable may not have directly committed the wrongful act. Instead, the law imposes liability based on their relationship to the person who did. In the Indian context, vicarious liability is well established, particularly in employer-employee scenarios. For example, if a delivery driver causes an accident while delivering goods, the employer might be vicariously liable for any damages. This principle ensures that victims can seek compensation from those with the financial means to provide it. Here are a few landmark case laws on vicarious liability in India. Lloyd versus Grace Smith & Co. Though a British case, it has influenced Indian law. It held that a principal is liable for the fraudulent acts of an agent if the agent was acting within the scope of their apparent authority. 3. Siraram Motilal Kalal versus Santanu Prasad Jaishankar Bhatt, 1966. In this case, the Supreme Court of India ruled that the owner of a car could be held vicariously liable for the negligence of the driver, even if the driver was not the owner's employee. 4. Pushpabai Purushottam Udeshi versus Ranjit Ginning and Pressing Co., 1977. The Supreme Court held that the master employer is liable for the acts of the servant employee if those acts are committed in the course of employment, even if the servant acts against the master's instructions. These cases demonstrate the various scenarios in which vicarious liability can be applied in the Indian legal